Welcome to the second lecture in the series about the good lawyer. If you haven't watched the first lecture, better to go back and watch that first because I explain some basic rules and principles. And this second lecture is focusing on one of these basic principles, confidentiality. As I already said in the first lecture, confidentiality means it's a rule that binds you as a lawyer, and it means that everything about the case, about the client, every information you get from the client or by other means that is part of the case, the advice, the representation, has some meaning in your legal work, is confidential and you can't tell anybody. So the basic rule of confidentiality is really, really simple. You cannot talk about anything regarding the case and the client to anybody. Full stop. That's the basics. And then, of course, because we are lawyers, we make exceptions and there are more interpretations of what that means exactly and in what kind of a scenario you might be able to waive a confidentiality and talk about the case. We will talk about all that later, but the basic rule, it's important that you just that it's ingrained in your brain, the basic rules: don't talk about the case or your client to anybody. Full stop. Confidentiality, if we look then a little bit deeper, what that means, there are some really important aspects to keep in mind. Not being allowed to talk about the case and your client means, for instance, that you can't tell anybody that you have a certain case. You can't tell anybody, of course, what your client said to you, or what kind of legal advice you gave your client, or whether your client is a really, really rude person. No. You can't talk about the case or the client, full stop. It also means that you can't talk about your client and the case once the case is finished. So it's not that once the case is finished, you can just blabber about it when you have a dinner with your spouse or when you go to a cafe with your friends. No, it doesn't stop. It's a lifetime commitment. That also means that this rule of confidentiality doesn't end once your client dies, or if your client goes to a different lawyer with the same case. So it's not limited in time, and it's not in principle not limited in scope, and it's also not limited with regards to what person you're talking about, with one exception. If you are a lawyer in a law firm where you share the same name and you share the same offices and you all work together, then you can talk about your case and your client with other lawyers in the same firm. But for instance, you can't talk about your case and your client with a lawyer of a different firm. Even if you're friends and if you know that person really well, the boundaries of confidentiality, they are very set, and you can only talk with colleagues in the same firm about a case. And it also means that you can't talk about the case and the client even if the person you talk to also has a confidentiality rule. For instance, if you have a client in a labor dispute and the doctor of that client comes to you, the case is done, finished, everything went well, and a year later the doctor of that client comes to you because the client now has medical problems and the doctor wants you to divulge certain information about the case, about the labor law case. And you know that being a professional just like you are, also a doctor is bound by confidentiality, but that doesn't matter. So it doesn't matter that the other person also has a confidentiality rule. You still can't talk about the case or the client. Within the exceptions that there are, in most jurisdictions there is the exception that if your client allows you to talk about the case, you can do it. But you still have to make up your own mind, and that goes to another principle that we will talk about a little later, independence. So it's not enough that your client allows you to talk about the case, for instance, to the press or to that particular doctor, or to a tax lawyer who advises him on a different matter. Your client can waive this confidentiality rule, but still that's only the first step. The second step is that you then have to make up your own mind whether it is in the interest of the client to talk about the case. There are, in the Netherlands, for instance, there are some court cases by the disciplinary court where a lawyer was allowed by the client to talk about the case, but the lawyer still decided, I don't think it's in the interest of the client to do that, even though the client allowed me to do that. And the client was not happy, and he brought a case in front of the disciplinary court, and the court decided that the lawyer was right. Even though the client allowed him to talk about the case, the lawyer has to make up his or her own mind, and if the lawyer comes to the conclusion that divulging information is not in the best interest of the client, even though the client allows me to do it, then he shouldn't do it. Another set of limitations is that there are certain circumstances in which there is there is another interest that is of such importance that the lawyer is allowed to break confidentiality. And the general case you most often get is that when your client tells you, for instance, that he just bought a gun and he's now going to go home and kill his wife, and he came to you for advice, not how to kill the wife, but what the consequences would be, what the legal implications is. In a situation like that, you are allowed to call the police because the life of his wife is in danger, and it's an immediate danger to a very important to something very important, in this case, life. So you are allowed to call the police and warn them in order to save the woman's life. In the Dutch context, I want to emphasize that this is a rule that you can break confidentiality. You are not obliged to. It's a subtle difference, but it's an important difference, which means that you still will have to make up your own mind as a lawyer whether this is a scenario, whether this is a situation where you are actually willing to break confidentiality. And in the example I gave you, much of your decision will depend, for instance, on questions like, is the danger real? Is it imminent? For instance, if your client talks to you that there's you are a divorce lawyer, and he talks about his wife, and he's really fed up with his wife, and he says something like, I just want to kill her. You as a lawyer, as an experienced divorce lawyer, you will know that this is not an imminent danger. Your client is agitated, and he hates these divorce proceedings. He didn't want to get divorced. So he says something in the spur of the moment, but it doesn't mean that he actually will go home and kill his wife. So a lot of it will depend on your experience in order to interpret what your client says in a sensible way. But if there is an imminent danger to the life and security of another person, that is a typical situation in which you as a lawyer are allowed to break confidentiality. There are rules and regulations about the scope and the limitation of the confidentiality principle that vary from country to country. To give you an example for the situation in the US, there is a rule or an exception that's called the crime and fraud exception. And what that means is that you are not bound by confidentiality if the client uses you and your services in order to commit a crime or a fraud. That's we don't have to go into details about that. That's just an example that, like I said in the first lecture, we are talking about basic principles. And if you are admitted to a bar in a certain country, you always have to make yourself familiar with the specific detailed rules and regulations of that country, because they might differ in details from each other. Important here is that you understand the basic principles of confidentiality, that it has no limitation in scope and that it has no limitation in time. Well, except when you die, it ends. You take your secrets to your grave. And the last thing I want to talk about is the relationship between confidentiality, which is a principle that governs the relationship between you and your client, and what we call in the English language, we call attorney-client privilege. In Dutch, we call it verschoningsrecht. The attorney-client privilege means what the possibility for a lawyer, if he or she is asked, for instance, by the government to divulge information or to give evidence against a client, or even in favor of a client. The confidentiality rule means that there is a privilege, which is called attorney-client privilege, which prevents you as a lawyer to be forced by the state or by a prosecutor or by an opposing party's counsel to divulge information. So it's, as it were, the same, or it's the different side of the same coin. Confidentiality is the governing principle, and as a consequence, everything that you talk about with your client and everything that you work for and the documents you get and the briefs you write are secured by attorney-client privilege. So no government can force you to disclose information, to give evidence, or to be a witness in a case where your client is involved. So it's the same thing, the different sides of the same coin, as it were. And as I said before, different countries have different limitations also to the attorney-client privilege. For instance, depending on who the client is, some states have limitations if the government is your client, and if, for instance, you know about something that is unethical that your government did, you advise them on the legal implications of torture. Think about the torture papers that were prepared by lawyers for the US administration during the Bush administration. Then the certain countries say, well, if the client is the government and the government did something that is unethical or criminal, and you know about it, then the attorney-client privilege doesn't hold any longer, and you can be forced to disclose these documents. But again, it is important to incorporate in your being, in your professional being, the general rule of confidentiality. And once you are admitted to a bar in a certain country, you have to familiarize yourself with the specific rules and regulations regarding confidentiality of that particular country. So these are the basic rules of one of the most important aspects of the relationship between client and attorney, the confidentiality. I hope you understood everything. And again, like with the first lecture, you can ask questions when we have the online chat session on Thursday. And I will see you next week with lecture number 3.